Greetings. My name is Nigel Bellchamber. I'm one of the principals of Amberley Gavel Limited, and I'm joined by my colleague Fred Dean, the other principal in the firm. Our firm has been contracted with AMO's Local Authority Services to provide closed meeting investigation services for over 140 municipalities in Ontario. What we're going to talk about today is some of the reasons why municipalities can go into closed meetings, that is, include the public, and some of the highlights of a few of our reports. Fred, let's start with the basic principle.
Well, Nigel, what we're talking about today, what we're fundamentally talking about is accountability and transparency of municipal government. Probably the key aspect of that is the fact that meetings of council and committees of council must be open to the public. When you see the word shall in legislation, that's mandatory. Now, there are exceptions that allow municipal councils to move into closed meetings. They're limited, and we're going to review those with you now and go through them. Always the starting point is meetings shall be open to the public will have access to it, and the clerk will have provided notice to the public that the meeting is occurring. And that's true of a regular council meeting, true of a special council meeting, and it's true of committee meetings. So let's go through the list, Nigel, of the limited permitted reasons to go into a closed meeting.
Thanks, Fred. These are drawn, not exactly word for word, but they're drawn from the legislation in Section 239 of the Municipal Act 2001. And the first subject matter that a council may go into closed session to discuss, doesn't mean they have to, but may, is the security of property of the corporation. Now, that can mean several different things, as we've seen in some of our reports. It might be the security of the property against theft or intruders, security system for your municipal office. It might be the internal control system for your cash at the arena and the system that you use. So there's a number of things like that. Doesn't mean all property matters, but it has to be the security of the property of the corporation. That's the first one. The second one is to discuss a personal matter about an identifiable individual. Some of these terms will start to sound somewhat familiar to you, especially if you've been around for a municipal government for a while. People used to use the phrases property, personal, and legal matters. Those no longer apply. You have to meet the specific test of the legislation. And a personal matter has to be about an identifiable individual. A personal matter might be a question about the person's health. It might be about the person's competency. It might be about their experience. It might be any one of a number of matters in terms of performance. But it has to be a personal matter about an identifiable individual. It's not all personnel matters. Issues around human relations issues can come up under another exception, as we'll see shortly. Personal matter about an identifiable individual might also be your opinion about someone else. That's you, a personal matter about you. That's your personal opinion. So there's a number of different things that fall into that category. The third one is the acquisition or disposition of land. What's acquisition mean, or what's disposition mean? Well, it means purchase or sale. It might mean renting. It might mean leasing. It could mean giving away or receiving as a gift land. These are matters with respect to transactions involving land or ceding control of land. And in doing so, why would this actually be a matter for a closed session? Well, if a municipality is looking to purchase a piece of property and is providing direction to its negotiators about the upset limit that it's willing to pay to acquire a piece of land, then you don't want your negotiating position closed prior to the negotiations taking place. Don't want to impair the ability of the municipality or the financial position of the municipality in discussions. Labor relations or employee negotiations. Well, if you have a union contract, the guidelines that you provide to your negotiator are labor relations matters. Or if council happens to be involved in the settlement of a grievance at one step or a final step of an issue, then that's a labor relations matter. Matters that are subject of a collective agreement can be considered as labor relations matters. Not all of them will be necessarily, but ones where you're providing direction and negotiating direction. Employee negotiations, again, that's fits well into the collective agreement side. All personnel policy discussions do not necessarily fit into this category, but if council were discussing what it might give as an increase the following year to its non-union employees, that could be considered a labor relations matter. So you need to be cautious about which ones you actually consider in closed session. And quite frankly, even though it might be permitted, it's not necessary to do it. You should always ask that question. Is it necessary to discuss this in closed? Or can we have this discussion in open? Most personnel matters don't necessarily need to be discussed in closed session. Fred, some of the other exceptions?
Nigel, the fifth reason, or the fifth category that council may move into a closed session is litigation. And the word is made. You said exactly this. These are discretionary. Council can make a decision whether to be in a closed meeting or not. When it comes to litigation, there are two things to keep in mind. Traditionally, litigation means court action, application to court, or litigation within court itself. The definition, though, in Section 239 is broader than that, and it includes not only court, but it includes administrative tribunals, OMB, for example. So if it's a matter that your council is giving direction to your lawyer or your planner or your staff or agent, you're entitled to do that at a closed meeting. Other important aspect of this provision is that it talks about not just litigation, that's present happening litigation, but also potential. Be careful with that. Potential means exactly that. It has to be real potential. It's not just, and I've had councillors say to me, Fred, we could get sued on anything we do. We run very dangerous businesses. That's true to some extent. This section only applies if the potential is real and not perceived. There's a special relationship between lawyers and their clients. So there's a special relationship between counsel and its lawyer. And lawyers are entitled to provide legal advice that is confidential to clients. So the Act, not surprisingly, allows for a meeting to be closed for a client counsel to receive advice from its lawyer. It's important, I think, that you receive that advice in an appropriate way. The best way to receive it is to have the lawyer in front of counsel to give the report and to answer questions. The second best way is to receive a report in writing from the lawyer so that all of counsel can read it and understand what it says. The lawyer is providing confidential information. The privilege that goes along with this is the privilege of the client, that's counsel, not the lawyer in terms of divulging what occurred. The way that, in my recommendation, you not do this is to have the lawyer talk to the CAO or the clerk in the afternoon, have the clerk convey that information to counsel. I do not think you are entitled to use this exception to have it delivered by a different party than the lawyer himself or herself. Important to receive that directly, either in person or in writing. There are other statutes that come into play as well. Let me just mention a couple of them. Under the Emergency Management Act, for example, the part of the plan may be developed at a closed meeting. And this makes sense. You're dealing with very confidential information with respect to your community. Statutory Powers Procedure Act, SPPA, also allows for part of the deliberations to be done at a closed meeting. That's fundamental. Nigel, let's move on.
Well, Fred, just one question that often comes up. Advice subject to solicitor-client privilege. Does that mean anything that the solicitor might present to counsel in closed session is caught by this?
No, absolutely not. That's a really good point. In fact, much of the advice I gave to counsel in Sudbury when I was city solicitor was given in an open public meeting. There was no need to make it confidential. It's information that is intended not to be shared between the client and the lawyer. be maintained confidential.
Okay. So this is the education and training provision, Fred.
And this is an important one, and it's one that you need to read with care. This came into effect in 2006, and when it first came before the legislature, it said just what is on this screen, that council may go into a closed meeting for education training. But added to the act, this was a third reading in 2005, added to the act were these two provisions. First, it's held for education or training, and secondly, and this is the key part, that at that meeting, no member, that's members of council, that's not staff, no member discusses or otherwise deal with a matter in a way that materially advances the business. That's a tough test. That's a really high test to meet. If you're dealing with something in a closed meeting that's education and a member of council says, I'll never support this, I don't agree with that, and I hope you won't support it either, you've just crossed the line. You are now materially advancing the business of the municipality. Be really cautious about this. A number of municipalities that I work with are very, very reluctant to go in for education and training. Really, if you can do your training in public, do so. Most of the orientation work that Nigel and I do after the election, and indeed during the term, is open to the public. There's nothing in orientation training generally, or very little, that needs to be done behind closed doors. Open your training up whenever it's possible.
Fred, one of the things we hear is, and it's now well established through some of our reports and some other reports, is that a briefing on current issues by the CAO to council, or briefing of council, calling it education and training is not education and training. Education and training means imparting new knowledge or new skills to enhance the ability of the member to do certain tasks. So for instance, if you're teaching someone how to use a new piece of software to access agendas and reports prior to a meeting, that can be training. However, the content matter of the reports, that's not education or training. That's briefing. That's a very different matter. So it's well understood that education and training is skills building, it's technical, it's not subject matter oriented. There are a couple of instances under which a meeting shall be closed to the public. One's been there for a while and the other one's relatively new. First is that if council is considering a request for information when council is the head for purposes of MFIPA. That's the Freedom of Information legislation that municipalities are under. Our best advice is that the council should not sit as the head. It's a very technical field. Most places delegate that responsibility to the clerk. Clerks can be trained in this. Councils often are not trained, and it's a very technical act. So we would suggest that council not get themselves involved in this so that they not find themselves in a position under this section. The second one is relatively new, and a meeting shall be closed when council is considering a report from an ombudsman, and that would be the provincial ombudsman or its own ombudsman, or a closed meeting investigator, and in some cases the provincial ombudsman is also your closed meeting investigator. So in those circumstances, whether it's an ombudsman or a closed meeting investigator, with respect to an ongoing investigation, in effect, an interim report. Not the final report. Final reports are to be made public, but if it's a final report, it's no longer an ongoing investigation. The investigation is complete. We, in the 100 or so investigations we've done, we only found circumstances once in which we thought it was advisable to deliver a meeting to the report to council on an interim basis, because we thought that the consequences of our report would have a significant impact on the municipality from a financial point of view, and so we thought it was important that we deliver them the interim report to allow them to prepare, and in fact to allow them to seek some additional legal advice, which they did. Didn't change our report, but it was in the interest of the municipality and its residents in order to do that. Rarely do we think that makes a difference in most reports. And quite frankly, political embarrassment is not a reason for delivering an interim report. So don't think that you'll find us delivering a lot of interim reports. However, ombudsmen frequently deliver an interim report to a municipality, so the municipality can respond publicly when the report's made public as to the changes that they've implemented in order to deal with the recommendations of the ombudsman, because sometimes they are quite detailed from an administrative point of view. So there is a better reason for an ombudsman to deliver an interim report to a municipality, and for the municipality to be able to prepare to deal with the final report publicly. It doesn't necessarily change the report, but it makes for better government when it happens.
Actually, just one point on that. When we issue the final report, our recommendation is that council place that report on the next regular meeting of council, or on a special meeting called before the next regular meeting to deal with it. In other words, get it forward, get it to the public as quickly as possible. There's always an expectation of the public that it's going to be released as soon.
There's no provision in the Act for the final report to be dealt with in camera, which is the same as in closed.
So we've dealt with the subject matters. That's the list. That is the entire list that is available. There are no other reasons for going into a closed meeting. You must fit within one of those limited categories. So the next question is, how do you get there? How do you get into a closed meeting? What are you required to do? Section 239 is very specific in terms of what must happen. You may not hold a closed meeting unless council or the committee passes a resolution at a public meeting, and that resolution must do two things. First, it indicates that council is authorized to hold a closed meeting. Secondly, it must state the general nature of the matter, or if there's more than one item, the matters that will be on that closed meeting agenda. You may not go into the closed meeting without that public resolution being passed. Again, we're back to this whole issue of transparency, the ability of the public to see, firstly, that holding the closed meeting, secondly, what the subject matters are going into the meeting. The last point on this is you can't add items when you get into the closed meeting. Even if it's an item that is permitted as a closed meeting item, you cannot do it if it is not on that resolution list that you passed when you passed the resolution at the open meeting. You're not permitted to. So if the clerk reminds the chair you can't go there, council members need to pay attention. The chair needs to control and say we cannot discuss that, we're not entitled to. This is really fundamental, I think, to how the public is able to see not only what council does at a public session making decisions, but also why it's going into closed and when it's going into.
So Fred, if we're in closed, we discuss the items permitted by the resolution, and while we're in there, somebody attempts to raise a third item, and in fact, council, you get the sense that council wants to, or might want to discuss this. How do you actually get into closed session to discuss that?
Let's suppose it's an upcoming OMB hearing, and we know that you can go into the closed meeting to deal with the litigation matter that includes administrative tribunals. At the completion of the first two items that were authorized by the resolution, council may go back into open session. Open the doors, let the public in, turn the cameras back on if you're video, you're taping your meetings. Pass another resolution authorizing a closed meeting for litigation, namely for the upcoming OMB hearing. Then you may go back into.
You're not hard, but there's a straightforward process you're supposed to follow. So when you're in closed session, can you vote? And often people will answer that question, no votes in closed session. Well, actually, there are votes that are permitted, but very limited in their application. First kind of vote that can take place in a closed session is for procedural matters. Well, what might procedural matters be? Well, number one, let's assume that you have in your procedure bylaw a curfew that says meetings shall cease at 11 p.m. unless a majority vote of council votes to extend the meeting by 30 minutes. That's a procedural matter. You could entertain that in closed session so that you didn't have your meeting automatically stop if you were at 10:48 or something during the closed session. That's one. Another procedural matter is to adjourn the closed session, quite frankly. That's how you get out of it. That's how you cease the meeting. Those are procedural matters. The other, and this is one is more important, is to provide direction. Direction to officers, agents, or those that are contracted on behalf of the municipality. You can pass a resolution to provide direction. I spoke earlier about acquiring a piece of land. And so your real estate agent or your solicitor or your CAO, you're providing direction to him or her in order to go out and negotiate for the acquisition of this piece of property. The only way he or she actually knows what you're prepared to pay or what the upset limit is or what the conditions are is if you provide that in a resolution and recorded by the clerk, voted on by the council, and duly passed in closed session. That way you have your direction. You've got your direction. Council can't undertake corporate acts. They can't actually buy or sell in closed session. They have to do that in closed by bylaw. But they provide direction to their officers or agents. Same way to your negotiator at the bargaining table. Same way you would provide to your solicitor if you were in the middle of litigation, or your planner if it was a particular position to take an OMB here, as Fred mentioned earlier. Resolutions are critical because without them, there's no actual documentation that your negotiator has in order to represent you. So it's important that those motions of direction be considered. And they have a standard wording that blank is hereby directed to. Should always start that way. Right?
No. Well, Nigel, I just think that it's important to understand that it needs to be in writing. When we're talking motions and resolutions, we are talking having it in writing. Everyone in that room, when they leave that night, needs to be clear what the direction is. And if it's just a conversation, nobody's going to be clear what and the confusion can occur. I know I saw that over the years. Really important to get it in writing. And if you're writing reports, which you should be to the closed meetings, that motion should be at the top of the report, so everyone knows when they're voting on it. The one last thing about votes is there's no such thing as consensus or straw votes. They're not allowed. They're not permitted under the Act. The Act allows just the types of votes that Nigel has outlined.
So the chair of the meeting doesn't go around the table and say, so is everybody in favor of that, or what do you think, one by one by one? Try and get consensus. Deal just like you do in a regular session. Motion is on the floor, moved, seconded, and debated and voted upon. That's how matters are determined. We have one final slide here, and it refers to Bill 68, which is currently before the legislature. Speaking here in December 2016, we expect it to be debated at committee sometime in the spring or in the winter session. And it proposes to expand the possible reasons for excluding the public from a meeting. We're not going to go into the detail of those because we're fairly certain that they'll change in some regard. So there's no point in muddying the waters by talking about what they might be or what Bill 68 currently says. If you're interested, you can go in and you can read Bill 68 on the Ontario Legislative website. It's there. It's a bit of a tough slog because you've got to go back and forth between the current legislation and Bill 68. But my advice is stay tuned. If you belong to a municipal association, and I think all of you will, in one form or another, whether it's a staff association or it's Roma or AMO or some other municipal association, I think you should have your antenna here on about this particular bill because there's a number of matters in it that I think you'll want to make presentations on, not just the closed session piece. But stay tuned for those committee hearings and ask your staff, quite frankly, your municipal staff, for their opinion on it. They should be well informed on this bill as well. Fred, any final remarks?
No, I think when we summarize today, what we're talking about is keep three things in mind when you're dealing with closed meetings. Starting point is always it must be public unless, and then the three things are, what are the subject matters for which we may or shall go into a closed meeting? How do you get into the closed meeting, and what can you do when you get there? Keep those three things in mind. Whether you're a member of council or a member of staff, it makes this act, this provision, much easier to comprehend and to deal with effectively.
Some of the best councillors I've worked with have often asked when a resolution to go into closed comes on the floor, turn to staff and say, at the time the agenda was put together, you recommended this be dealt with in closed session. Is it still necessary? Nothing wrong with asking that question. If staff say yes, that's fine. If they say no, then council should be well advised that there's probably no need to go into closed session. The other approach on that is to wait until you're in closed, and I have had experience with councillors saying, do we really need to deal with this in closed session even though we may? And often the answer is, well, gosh, I guess we don't now. So err on the side, if you can, of transparency, of openness, because secrecy breeds suspicion and concern. In closed meetings, many people equate those, many members of the public are not as familiar with the Act as you are, and they'll equate those with secrecy. And don't be surprised if the media likes to add up the number of minutes you've been in closed session over a year and report it. And even though it's quite legitimate, it appears publicly to be a negative. So thank you for this opportunity.
I agree. Thank you.